There's been a lot of commentary about that incident at Manchester Airport, which I'm not really going to speak about. And today's video is essentially why I'm not going to speak about it. Why is this? Well, first of all, as some of you may know, as well as lawyering, I also used to do what we call night lawyering for newspapers. I used to check, their stories were okay and safe to go out, and that was things like mainly defamation, but also contempt of court, some IP, copyright issues, that sort of thing. But one thing I notice when, consuming media is, if there was ever a story that I actually had some first-hand personal knowledge of, I can always look at the media report and go, well, actually, that's not quite right. I mean, sometimes it was wildly inaccurate. Sometimes it was getting the gist of it. But, there were still sort of errors in there. Some were significant, some weren't. But, this is the danger in that just seeing what the media have, first of all, do they have the expertise to report? I mean, especially for legal proceedings now, it's very sad, but we don't have the old court reporters anymore. I can only think of a few sort of dedicated professional court reporters, with legal training. Now it's just they get all the stuff from the, press agencies or just the press releases. They don't do their own research into it. And so there is this danger when it comes to sort of, legal matters, that you don't get the whole story. Now, I noticed my last video I did on the Letby thing. I was mainly commentating on why certain evidence had been, quotes, withheld from the jury, and indeed why people weren't allowed to report on it. The thing to remember is, when you look at a case, most people, they have, competent representation. And the defence know what arguments they think will go down well and what won't. They see the whole of the evidence. They see what we call the unused material. They have access to everything. And when you're, preparing to either prosecute or defend a case, or indeed in a civil case, bring the claim or defend the claim, you have to sort of play your cards wisely. You can only play the cards that you're dealt. But these are why you instruct lawyers. We have to make the decisions as to what we think will work and what won't. And yes, the New Yorker article, there have been some very enlightened commentators commentating on the Letby case, but ultimately it was for the defence to decide what defence they wanted to do. And remember, when you see things like these articles in the press, they're completely unchallenged. If this were evidence was to be presented in court, then it'd be open to cross-examination. They could call, counter-experts to sort of say, well, that's not right, that might not be right, you've misinterpreted that. And also, they're basing things on access to what's in the public domain, not all the material that the lawyers have. So that's something to bear in mind. I mean, like I say, I'm not going to commentate on, any particular decision. I tend not to second-guess juries. I mean, don't get me wrong, we do have miscarriages of justice, and we have to accept that. But my starting position is always, there's been a long trial, they had competent representation, and in my experience, juries are really smart. I mean, it's worth remembering in the Letby case that they didn't convict on everything. So they were clearly thinking about it. They weren't just going, oh, something horrible has happened and somebody must pay for it. There were certain counts that there had to be retrials on because the jury couldn't decide, which I always think is a sign that they're taking things seriously. But similarly with the Manchester thing, I mean, the other thing to remember is, contempt of court. I did a video recently about how the Law Commission are asking for submissions on, what contempt of court should be, especially in the modern era with social media, and the fact that, we can't control what happens outside the jurisdiction. This is like, remember showing my age here, the old spy catcher thing, where there was a worldwide injunction saying nobody could comment on the contents of the book. But of course that, didn't stop people in other countries going, well, we don't care. You can't tell us what to do. And that's the same here. And now, with access to the internet and VPNs and things like that, you can just access this material. I mean, the interesting thing is injunctions are what we call equitable remedies. They're not a common law remedy. And equity is full of wonderful maxims. And one maxim in equity is equity will not act in vain. In other words, if you try for an equitable solution and the court say, well, actually, it doesn't matter, technically you're entitled to it, but it wouldn't make a jot of difference, then that is actually one reason for not allowing the injunctions because it would be pointless. Although the counter to that is they sometimes say, well, we need to at least send the message that we disapprove of this and people shouldn't be doing that. But just bear this in mind, evidence in the public domain comes out in dribs and drabs. I mean, we've seen, first of all, there was one video and lots of people commenting going, oh, this is terrible and this is awful, and demanding, people who should know better as well, politicians who should know how the legal system works, which is that politicians don't have a say in, individual court proceedings. Politicians can, they're the legislature, they're lawmakers, they can pass any laws they want. But once the laws are passed, they hand it over to the legal system to deal with. So it's up to the Crown Prosecution Service, who should be prosecuted and what they should be prosecuted for, or indeed private prosecutors. But generally speaking, politicians saying, we demand you do X, Y, and Z. Well, no, the CPS operate to a particular code. They have to show that, first of all, there's a realistic prospect of conviction, and also that it's in the public interest to actually proceed with the prosecution. And politicians should know better than to interfere, with those charging decisions. I mean, prior to, the CPS being established back in the 80s, technically speaking, all prosecutions were private prosecutions. It was the police that actually brought them and decided. And, the danger with that is, no disparaging to the police, but how objective were they? If you knew somebody down your local NIG, you were perhaps less likely to be prosecuted than if the local police just, had it in for you. So that's why we tried to have this independent prosecuting authority. And also now we've seen that, other videos have come out that perhaps shows a different context. But ultimately, if this goes to a trial or to disciplinary proceedings, then all the material will be available to the relevant tribunals, whether that's a criminal court or a disciplinary tribunal, and it will be up to the respective parties, whether that's the prosecution and defence in a criminal trial or the disciplinary body and the defence if it goes to a disciplinary. It'll be up to them as to what arguments they run and how they run them. I mean, like I say, I'm not saying people shouldn't have opinions on things. I mean, I do these videos just try and highlight stuff that's out there in the law. But what I try to do is give you the context as to explain, why has this happened? Why has somebody made this particular decision? Why isn't this happening? How come nobody's done this yet? Well, I try to explain that. But like I say, the big problem with the Manchester thing is, okay, it's all on video and it's out there. People are making lots of comments. If this goes before a jury, whether it's, whoever is prosecuted, the idea is that jurors try the case purely on the evidence presented to them. Because the idea is that's the only safe way of doing it, because it is open to challenge then. People can produce their own evidence to rebut that. They can cross-examine to challenge that evidence. Whereas if you just hear something down the pub, I mean, this is quite a common direction jurors get. They will sort of say, you will try this only on the evidence. And judges will say, look, imagine you were up for you yourself were up for something, whether it's a criminal trial or you're in trouble at work. Would you want the decision maker taking into account something they'd heard down the pub about you that you didn't know about and you didn't get a chance to say, well, hang on, no, that's not right and I can prove it? So, just try and bear all that in mind, and that's why we have contempt of court rules, to try and stop this speculation. I mean, I am a big subscriber to, actually, jurors tend to take their job very seriously. And I think if you say to jurors, ignore everything you've seen on Twitter, ignore everything you've seen on the internet, just try it on the evidence, I actually trust them to do that. I mean, I took part ages ago, decades ago, God, I feel old now, where we actually did a trial. We ran about 20 times in front of random, we've got people to be jurors, members of the public, and we ran the same case about 20 times with different variations on how we presented the evidence and what we said in closing submissions. And then what we got to do then was see what verdict they returned, but also we could get them to do questionnaires and interview them, because that's one thing in the UK, you can't speak to jurors about how they make their decisions. It's just binary, isn't it? It's like, guilty or not guilty, or we can't decide. You can't question them. And that's one of the best arguments, I think, against jurors is we don't know how they arose at their decisions. Personally, I think there's an easy way around that, which is to have what we used to call special verdicts. So you say to the jurors, you are the arbiters of fact. Here's a list of the factual issues in dispute. Tell us what you think the facts of this are, and then leave it to the judge perhaps to apply the law. But I think the system works reasonably well at the moment. But yeah, like I said, just try to bear that in mind when people are sort of commentating about this. I mean, I remember there was I think it was an advert for The Guardian that they tried to do this, where it's a video clip where somebody looked like they just mugged a little old lady, but then when you zoomed out, you saw it was actually rescuing some orphan child or something like that, and it was all about, yes, you need the context, you need the context. I mean, don't get me wrong, some of that stuff in those videos does look pretty bad, but there are no blanket assumptions you can make on this. However unlikely, it's the old north by northwest scenario, isn't it? I actually did that once. I remember a friend was defending a case in the court next to me, and it was absolutely no hoper because it was pretty much everybody come across the guy who just, like while he was stood there with the knife in the guy. And I actually said, have you ever seen North by Northwest? And she was like, no. And I was explaining the plot and saying, well, good luck with that. And actually, apparently, she did her opening speech to the jury was, members of the jury, have you ever seen North by Northwest? Whether they had or not, they clearly weren't convinced about it because of it, they did return a guilty verdict. But there you go. So just a little ramble. I don't normally give my personal opinions on things, but people seem to like what I did last time. So there you go. As always, hope you found that vaguely useful, vaguely interesting. Where am I today? I'm at Kennel Vale again, the old gunpowder works, because I'm sort of, trying to make a pun about there's lots of incendiary reporting in the press, but I just couldn't be bothered. But there you go. This is a lovely spot, and now, while we're having our 2-day-long summer, I'm going to go find somewhere nice to edit this. Oh, right. This is. I always remember exactly this moment when I finish. It's almost like Pavlovian now. Please, if you did, please consider liking, sharing, subscribing. Although I've got my 25,000 subscribers now, so I'm sort of quite happy with that. Because what's the next milestone? It's about 1 million years away, isn't it?